legislative responsibility, and the cost of inaction. Esteemed members of the Florida legislature, over the past 35 years, this body has been aware of the injustice enshrined in Florida Statute 768.21 subsection 8, hereinafter subsection 8. 35 years of debate, deflection, and delay. However, the issue can no longer be ignored. No longer can it be dismissed as something to be studied further or postponed until a more politically convenient time. The time for action is now. You have before you the knowledge. You have before you the bills that seek to correct this grievous wrong. And you have before you the moral obligation to act. Subsection 8 is not an abstract legislative misstep. It is not a theoretical injustice. It is a law that robs families of their legal rights, shields negligent medical professionals from accountability, and allows dangerous doctors and nurses to remain at the bedside, continuing to put patients' lives at risk. The failure to repeal this statute is not just a failure of policy. It is a failure of duty, a duty to protect the citizens of Florida from harm, a duty to ensure that justice is available to all, and a duty to uphold the fundamental rights enshrined in the Florida Declaration of Rights and the U.S. Bill of Rights. Every year that this law remains in effect, more Floridians die at the hands of negligent medical personnel who are shielded from public scrutiny. These are not hypothetical deaths. They are real people, real families shattered by preventable medical negligence. And yet these negligent medical professionals continue to practice, their records hidden from the public, their misdeeds insulated from the very system that is supposed to hold them accountable. When a doctor in Florida commits egregious negligence, when they ignore clear signs of distress, fail to follow basic medical protocols, act recklessly, and cause harm, the people of this state expect they will be held accountable. They expect that such behavior will be exposed, scrutinized, and punished. However, none of that happens for families who fall under subsection 8. Instead, the legislature has created a system where these negligent individuals remain in practice. Their negligence continues unchecked, and Floridians suffer preventable harm. And who bears the responsibility for this ongoing injustice? Who allows these dangerous practitioners to remain at the bedside, treating patient after patient with no fear of legal consequence? It is not just the hospitals. It is not just the medical boards. It is you, the members of this legislature, who have year after year chosen inaction over justice. Let us be clear, deferred justice is denied justice. Saying that you will take up this issue in the next session is saying that you are willing to let another year of unnecessary deaths occur. Saying that you need more time to study the matter is saying that the lives lost in the meantime are an acceptable cost of legislative hesitancy. The citizens of Florida deserve better. The citizens of Florida demand better. History will not be kind to those who had the opportunity to correct this wrong, but chose instead to bow to political pressure, cower before lobbyists, or pass the burden to the next session, as has been done for 35 years. The blood of every patient lost due to medical negligence that could have been prevented is on the hands of those who refuse to act. That is not rhetoric. That is reality. Every vote against repeal and every refusal to move these bills forward is a vote to allow negligent doctors and nurses to continue endangering lives with impunity. If you fail to act, then you should be held to account by your constituents as enablers of legalized negligence. This is not an issue that can wait. Human lives hang in the balance. Every legislator seated in this 2025 session has a choice. Stand for justice and protect the citizens you were elected to serve, or remain complicit in the continued suffering and death of Floridians under a law that has no place in a just society. There is no neutral ground. There is no justification for delay. There is only the question of whether you will do what is right, whether you will act now to repeal this law and restore justice to the people of Florida. I have made my arguments available to every member of this legislative body, including a path to satisfying all stakeholders and reaching Nash equilibrium. Please see my videos titled The Hard Questions Regarding the Repeal of FS 768.21 subsection 8 Must Be Asked, and my petition to repeal FS 768.21 subsection 8, A Better Way Forward in 2025. In these videos, I discuss the Michigan model based on NASA's systems error approach and the questions that must be answered to reach Nash equilibrium. You can find these recent videos on my YouTube channel, or you can contact me at philip@legalizednegligence.com, and I will send you a copy of the transcripts. You can also go to legalizednegligence.com and look under the Articles tab where I have uploaded this body of work. The clock is ticking, and the time is now. The citizens who elected you are waiting for your response. Respectfully submitted, Philip Glickstein, Personal Representative for the estate of Winnell A. Glickstein.